Hello everyone, so far we've done 3 compilation videos and now we have 3 more compilation videos to go. This is part 4 of chapter 1 of the RPC. Are you ready? Let's go. Rule 30. Lawyer as Officer of Court. Welcome back guys. This is part 4 of the RPC, which talks about a lawyer's relation with the court. Rule 30 talks about a lawyer as an officer of the court. Now remember what we talked about in Rule 14 and Rule 15, where we said that as a lawyer, your duty to uphold the law always supersedes the duty to satisfy your client. This rule is just a fun reminder of that. Even though you are not in the bench, you are still an officer of court. This means you can't conduct yourself in a manner that obstructs or delays the administration of justice. You must assist the bench in the quick and fair dispensation of justice, even if they end up reflecting as failures on your track record. And that is it for Rule 30. Rule 31. Duty of lawyer to court and conduct in court. Let's talk about Rule 31. You have to always treat the court with honor and dignity. While the court is in session, keep those earpods in your bag. Don't chew gum, or discuss in loud voices, or play games with your phone. If you don't like the judge's conduct, do not tell the judge to his face in open court that he's corrupt or he has abused his office as a judge. That's disrespectful. It is better to submit such an allegation to the appropriate disciplinary body for judicial officers. If you have made an undertaking to the court as a lawyer, either personally or on behalf of your client, you must comply with it. Failure to do so will be professional misconduct on the face of it, and that will be seen as disrespecting the court. A lawyer should avoid discussing a pending case with a judge who is trying the case in the absence of the opposing lawyer. This is to promote fair hearing. The lawyer should also avoid delivering any letters, memorandum, or other written communication to the judge without also sending a copy of such documents to the opposing party at the same time. And that is it for Rule 31 of the RPC. Rule 32. Candid and fair dealings. Let's talk about Rule 32. Candid and fair dealing with the courts. As a lawyer, you must always strive for a fair and honest relationship with the court, because you're an officer of the court. This rule gives us a list of how to be candid and fair. For example, when you are in court, if you know the latest authority in a matter you are handling that was not disclosed by the opposing lawyer, you have to let the court know about it, even if it will be against your client's case. Remember, upholding the law always supersedes satisfying your client. Also, always disclose the identity of your client to the court so that the court will take notice of your client. Another example is to avoid telling the court facts that you know are irrelevant or facts that can't be supported by admissible evidence. Also, while conducting cross-examination, don't ask irrelevant questions that are meant to degrade a witness or another person. Don't state your personal knowledge of the facts in issue, especially when you are not a witness. Your personal opinion shouldn't form the basis for the correctness of anything. State the facts, bring your evidence, and let the courts decide. Another way to be candid and fair is to always comply with known local customs of courtesy of a particular court or tribunal. Also, don't intentionally, or as a matter of habit, violate rules of procedure or evidence. Another way to be candid is to make sure that you don't intentionally misrepresent facts to the court. In other words, don't lie to the court. Also, don't knowingly cite overruled decisions or repealed statutes to the court in order to mislead the court. Another way to be candid and fair is to not mislead your opponent by stating or proving facts as if they are true, or by holding back key points in your opening arguments to surprise them later. Also, don't bring evidence that you know the court should reject. Don't try your luck. If you know a matter is false, don't promote it as if it's true. In short, don't do anything that will constitute an abuse of court process. As an officer of the court, avoid anything that prevents you from aiding the court in the proper administration of justice. And that is all for Rule 32 of the RPC. Rule 33. Trial publicity. Let's talk about Rule 33, Trial publicity. This rule simply states that as a lawyer, when you are engaged in a civil or criminal matter, avoid making public comments about the case. This is because you may unknowingly make statements that will prejudice or interfere with the fair trial or decision in the case. These extrajudicial statements could be made in the newspaper, radio, television, or social media. If you are caught, such action may amount to contempt of court, so it's best to avoid public comments. Now, I've seen people say stuff like, because of lis pendens, they can't discuss the matter. And while lis pendens is Latin for a suit pending, that is not the right phrase to use in this instance, as that refers to an ongoing lawsuit affecting a property. The right phrase to use in that instance is that the case is sub judice. This means that the matter is under judicial consideration and therefore prohibited from public discussions elsewhere. This is used generally, not just for property. And with that, we've come to the end of Rule 33. Rule 34. Relation with judges. Let's talk about Rule 34. Relation with judges. This rule simply states that you cannot give the impression that you are seeking favor from the judge in respect of a matter pending in court. The judge is an unbiased umpire, and as a lawyer, you must respect that. Even if the judge is your grandfather, for the purpose of the proceedings, he ceases to be your grandfather. This ensures that justice will be done to the matter, devoid of bias or favoritism. And that's all for Rule 34. Rule 35. Lawyer and Tribunals. Let's talk about Rule 35. Lawyer and Tribunals. It simply requires you to give the same respect and courtesy you would give a court. Treat the tribunal with dignity and respect. Rule 36. Courtroom Decorum. Let's talk about courtroom decorum. You have to respect the written and unwritten rules of the legal profession as it relates to decorum. Be courteous, dress well, treat the court with respect and decency. Now, when it comes to proper dressing, avoid attention-seeking attire. For the men, no dreadlocks. For the ladies, no flamboyant hairstyles. In courts of superior record, all lawyers must appear in their robes and wigs. For the dress code, men should wear a black or dark blue 2-piece or 3-piece suit, a white shirt with a winged collar, a bib, black shoes, preferably Oxford, and a pair of black socks. Alternatively, the men can wear a white collarless shirt with the white detachable wing collar, 2 studs for the wing collar, a bib, a black and grey striped trousers, a black sleeved vest, black Oxford shoes, and a pair of black socks. For women, wear a black or dark blue dress, add a jacket if you prefer, and wear a white collarette, then put on black shoes. In inferior courts of record, a black or dark blue suit, white shirt, a dark tie, with a pair of black Oxford shoes will suffice for the men. Women can wear black formal dressing as well. You cannot wear a wig and gown in the inferior courts or outside the court premises. Now let's briefly look at some common practices of the courtroom. Firstly, always be punctual. This gives you time to gather your thoughts and write your name in the counsel list. Also, make sure you avoid the front seat. That's called the inner bar, and it's reserved for senior advocates and live benchers. In court, you should always rise when addressing or being addressed by the judge. You have to make sure to address the judges in the appropriate manner. In the Supreme Court and Court of Appeal, address them as "My Lords." In the High Court, address the judge as "My Lord" or "Your Lordship" if it's a male judge. If it's a female judge, address her as "My Lady" or "Your Ladyship. In the magistrate courts that are not Lagos, judges are referred to as "Your Worship." In Lagos, however, the magistrates are referred to as "Your Honor." In the area or customary courts, the judges are referred to as "Your Honor." You must always take permission from the court for almost everything you do. Always thank the judge for almost everything he says, even if you don't personally agree with them. I believe the phrase is, "as the court pleases." Always make sure to study the court and the judge presiding. Take note of features like punctuality of your judge, whether or not they require multiple recesses, how the judge prefers to be addressed, whether the judge is easygoing or very strict, the writing speed of the judge when recording, etc. It's also important to take the hint of the court. If the judge says he is ill, then it will be wise to seek a short adjournment. If you have any objections, arguments, observations, etc., address the court directly, not the opposing lawyer. Avoid exchanging banter and arguments with the opposing lawyer. Finally, don't be involved in any undignified conduct which may be degrading to the court. And that's all for Rule 36. Rule 37. Employment in criminal cases. Let's talk about employment in criminal cases. As a lawyer, if you are defending a person who has been accused of committing a crime, you have to put all necessary facts before the court so that justice will be done. Let the guilty conviction be reached because the defendant is actually guilty of the crime, not because of your negligence. You also can't offer to stand bail for your client. In murder cases or other serious cases like capital offenses, the defense counsel has to ensure that he personally conducts the case, as long as his fees have been duly paid. Of course, if there are unforeseen circumstances that come up, another person can conduct on his behalf until he comes back. Where the defendant himself has disclosed facts which clearly show his guilt, The lawyer should not abandon him on the grounds that the defendant confessed to being guilty, but should try to discredit the evidence of the opposing party pointing to the guilt through cross-examination. Now, with that being said, the lawyer shouldn't present inconsistent evidence and testimonies that he knows are false to the court. If you're a public prosecutor, the main goal is not to secure a conviction, but to see that justice is done. As a public prosecutor, if you know that the charge you are bringing to court is not supported by probable evidence, then don't start the criminal action. That's malicious and an abuse of court process. During the trial, a public prosecutor should not suppress facts or hide witnesses that can establish the innocence of the defendant. If the public prosecution knows about any evidence that will vindicate the defendant, or at least lessen the punishment of the defendant, he should let the defense counsel know. Or in the case where the defendant has no lawyer, he should let the defendant know about such evidence. And that is all for Rule 37. 38. Lawyer for an indigent accused. It's time to talk about the last rule in Part 4 of the RPC, Lawyer for an indigent accused. Usually, in the legal aid program, lawyers are assigned to defend poor people who cannot afford litigation. If you've been assigned to such a case, then you have to do it to the best of your abilities. You cannot opt out unless you have substantial reason to. Just because a person is poor does not mean that he shouldn't have equal access to justice. And that's the gist of the rule. And with that, we've come to the end of Chapter 4 of the RPC. Next will be Chapter 5, which will be dealing with the proper attraction of business. As always, thank you very much for watching, guys. Like, subscribe, share with your friends. It's so amazing being in 800 subs. We really appreciate you guys staying around. Anyways, time to work on the next one. See you soon.